Please rise. Hear ye, hear ye, hear ye. The Supreme Court of the great state of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save the United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the oral argument calendar of the Florida Supreme Court. I would like to say that our marshal is certainly back in very fine voice. Last month he had a little laryngitis, so I'm glad that you're here when he is recovered. The first case in the oral argument calendar this morning are consolidated cases of Pollock and Leeds versus the Department of Highway Safety and Patrol. I understand that counsel is going to divide the argument, and so the marshal is going to give control of the lights. So, Mr. Citron.
Good morning, Your Honors. My name is Dan Citron, and I represent Stephen Pollock, personal representative of the estate of Alyssa Pollock. I'm going to divide my argument up into three bases. First of all, the basis for this court's jurisdiction. I'm going to propose a new test to eliminate the Trianon situation, and I'm going to apply the facts in this case to the new test. First of all, the District Court of Appeals decision conflicts with at least 5 different decisions of either this court or other district courts of appeal. The first case that it conflicts with directly is the Trianon case, which says that the operator of roadways has the same duty as that imposed upon private citizens. In the third DCA case, they said that they do not have a duty of care. They only owe a general duty, even though they're operating this particular roadway. And Trianon also states that once a governmental entity takes control of property, it has the same common law duty as a private person to maintain the property. The third DCA disagrees and says no. This decision also conflicts with the Bailey versus Stark decision. This court's decision which said that somebody that owns property or controls property has an obligation to maintain it, and that it is under a duty to make the streets safe and to remove the obstruction once it is aware of the condition or should be aware of the condition. The Third District Court of Appeals decision also conflicts with this decision. In addition, the 2 certified conflict cases directly and expressly conflict. Fourthly, there's a case out of the 5th DCA called Hoover versus Corrington, where the 5th said that where the DOT, the Department of Transportation, was aware of hazardous flooding on the roadway, but failed to provide warnings or make the conditions safe, the DOT could be held liable, and there was a duty. And fifthly,
just on all of these, you're making an underlying assumption that the Florida Highway Patrol is in the same status as the DOT or a state or a city. Is that a proper assumption to make as we proceed into the analysis that we must make here?
It absolutely is, Your Honor, because in their statute, I think it's 321.05, it says that the Florida Highway Patrol has the duties, the following duties. And part of those duties are to patrol and to control the flow of traffic within the highways. Nobody else has that duty. The only entity that can go out there and with a police car and handle the situation is the Florida Highway Patrol. The Department of Transportation cannot do it, and that's how the system was set up. This duty is different than the general duty of enforcement of the laws. And specifically in 321.05, they differentiate between the duty to patrol and control, and later on talk about the enforcement of the laws.
You said that you were going to propose a test that would do away with the Trianon categories, but if we were to apply this in the Trianon categories, it's your position that this is a road maintenance case as opposed to a public safety case?
It is a Category 3, yes, essentially a road safety. It could also fall into 4. The problem with Trianon is that nobody can tell the difference between a 2, 3, and 4. 2 is sovereign immunity, 3 and 4 are not sovereign immunity. So that's the problem with the Trianon test, and it's been criticized heavily certainly by Justice Shaw in his numerous dissents on these issues.
So you would say, look, this really is no different than if the DOT was charged with maintenance of the roadway, because you said they were the operator of the roadway, and they're not the operator of this roadway, are they?
They are, because they are the only ones who have the ability to patrol and control, is the wording of the statute, this roadway. And that goes back to a dissent that was set forth by Justice Wells, joined by Justice Harding, in the Department of Natural Resources versus Garcia, the beach case, where both Justice Wells and Justice Harding said, well, look, they didn't have the obligation to control, and it's the obligation to control that governs. And you cited to the Bovis case, and you said whoever's in control is the one who has the obligation to control and maintain the premises. And the only one that could do that is the Florida Highway Patrol. The fifth basis for conflict is the first DCA's decision in Hartley versus Floyd. And basically, it was a case where somebody was out in the ocean, and the wife called up and said, my husband's out in the ocean. Somebody said, I'm going to send somebody out. Same thing that happened in this case. Florida Highway Patrol said, we're going to dispatch somebody, don't worry about it. And in that case, which directly it conflicts, the first DCA held that, in fact, there was a duty, and it was an operational duty.
Well, you
Okay.
Justice
On
Glenn.
this duty to Highway Patrol has the obligation to control the highway. If we assume a situation where it isn't someone stopped on the highway as we have, but say a hole just appeared in the highway and was causing a problem, what would you contend is the Highway Patrol's obligation in that situation?
Okay. Now that's a closer question. And that comes into a quandary as to whether it is in fact the DOT or the Florida Highway Patrol. If in fact it comes to a situation where there's an issue that they have notice and they have the ability to control it because it's part of their patrolling obligation under the statute, then potentially there can be liability on the part of both entities, and I believe that was spoken to in the Bovis case, which Justice Wells referred to in his dissent.
What is the difference that, or the extremes? We have a vehicle proceeding too rapidly. You would agree that's a law enforcement situation, would you not?
In this case, no, sir. There was testimony.
I understand who hit them. If we're assuming we have the danger is a speeding vehicle, that's a law enforcement situation, I would assume that you would agree with that. And then on the opposite side, a vehicle proceeding too slowly or at stop. Why is that not a law enforcement situation as opposed to a road maintenance or property maintenance type situation?
I think that very well may be, and that's very different than this situation. This is a situation where there's a vehicle stalled in the roadway, there's an obstruction in the roadway, and somebody has to take some action to remove it or to warn of it. And but better to take the action than the person who has the duty under the statute to do so. It kind of goes to Judge Anstedt's I think it's the Witt versus Silverman decision, where this discussed the obstructions to motorists, citing to the restatement, and says that a possessor of land, and the FHP is in control of the land. A possessor of land is subject to liability to others outside the land for physical harm caused by a structure on the land which the possessor realizes or should realize will involve an unreasonable risk of harm if the condition is created by a third person, but reasonable care is not taken to make the condition safe after the possessor knows or should know of it.
Isn't that a great leap, though, for you to analogize the state's highway system with a piece of defined property that a property owner is in absolute and complete charge of, and therefore, now we can go back way to the common law and talk about the existing obligations of a property owner that have traditionally been followed. That's a huge leap to go from there and talk about an extensive state highway system, and that the law enforcement agency that is charged with patrolling and enforcing the state laws about that is now thrust into the position of that private property owner. And let me use that question as you're spending an awful lot of time talking about the potential conflict cases, and then you're telling us and citing dissents, and that you're going to come up with an alternative theory to what the existing law is. I think you need to focus on what your best shot is here with reference to the rule of law that you want to come out of this particular case. What would you have us hold as your best shot as the law to come out of this situation? Is it that we're going to analogize this to the private property owner and make the Florida, is that your best shot?
No, sir. My best shot is your decision, not your personal decision, but the Trianon decision, which I dislike the test. But in the Trianon decision, Justice Overton, who is, always been on the side of sovereign immunity, he himself stated when he wrote the opinion that the operator of roadways has the same duty as that imposed upon private citizens. That's my best shot. This court's own decision 17 years ago that says the exact same thing that I'm asking this court to hold today.
Well, the facts of this case, though, are sort of stronger than that general rule of law, aren't they? I mean, can't we, in terms of distinguishing other situations, look to the fact that the Highway Patrol actually was placed on notice and was supposed to dispatch a vehicle to the scene, and someone just made an error, failed to exercise reasonable care in entering it into the computer? I mean, why do we have to go decide whether they are the operator of this roadway or not? No one disputes that they had the obligation to, once the call was made, to act in accordance with what they knew to be the hazard. And don't we just have to get around whether there's this special duty, general duty situation that has developed in the case law, that this is really a situation where this is a foreseeable risk? Is that a better way to analyze this case, or do you think we have, because I think the problem with your saying that they're the operator of the roadway is that, as Justice Lewis was starting to say, this could open up a whole lot of cases that really don't fit into this very, very narrow circumstance. So can you help me with that?
Well, sure. The other alternative is just to ask if this activity is, and this is the test, is there a common law or statutory duty of care? And if it's operational, then it is. And operational is any act that is ministerial, does not require planning. This was simply a ministerial act that the duty officer failed to do.
Thank you, counsel. I think your time is
Thank
up.
you very much.
Mr. Levy.
May it please the Court, my name is Jay Levy. I represent the Leeds. Justice Pariente, I ascribe to the way you view this case. I view this case as relatively a very simple case on compelling facts. And not to belabor the point, but the facts are tragic in this case. There was a call made to the FHP. The computer operator took the call, said, we'll send somebody out. Never entered into the computer. As a result, the operator never had the call on the screen to send the trooper. 45 minutes later, my client is driving a vehicle west on the Palmetto Expressway in Dade County and crashes into the back of the stalled vehicle, which could not be seen because it is sitting on the downside of the...
But don't you run right into Everton?
I don't believe that Everton is a problem, because Everton, Your Honor, is a judgmental decision. In Everton, as I recall the case, the policeman had the opportunity to arrest or give a notice to appear and chose to do what he has the discretion to do. In this case, we believe that this case runs smack into the, I believe it's the Hartley case from the First District. In Hartley, which is very, very similar to this case, the lady called and said, "My husband hasn't come home. Could you go down and check the boat ramp?" The person on the other side had no obligation to do that, but he said, "We will send somebody." In a very, very well-reasoned decision, the First District held that they didn't have a duty to do anything, but once they assumed that duty, it became an operational function. They could be liable like everybody else. When they failed to send somebody down to check it, they would be liable like the state. And that's always the way I have understood the distinction between planning level, operational, to talk in the words of commercial carrier.
But again, when you carry that out, are you going to say that if somebody calls and says that there's a dangerous driver on the road, and the person there that's answering the calls, the dispatcher or whatever, says, "All right, well, we'll send somebody out to investigate"? In other words, you're going to go on and on with reference to what the reports are. There's a report that somebody is breaking into the home, and are you now going to hold the police department liable because they didn't get there in time to stop the burglary or the whatever takes place? In other words, traditionally it appears that under our case law, we have not treated those agencies as being liable that have this general function of responding to calls like that, this general public safety requirement. So how would you distinguish the situation of calling the dangerous thing there, but calling and saying that there's a drunk driver out there weaving back and forth on the highway?
I believe it's the nature of what they were called on to do in this case. They were called to deal with a static condition and obstruction. They were not called to deal with what I would consider to be an active, ongoing police function, a chase, a burglar, something we know under the Wong case, we know under the Elmer case, that those kind of things, which involve allocation of manpower, decisions on how to do things, discretionary calls, are traditionally police functions, and I don't question that here. But here, and again, I don't want to belabor the evidence, but it was clear that there were 8 or 9 troopers who could have made it here, no problem, to just put their light on, sit on the top of the bridge, and warn people, because that's exactly what the Dade County Police did when they showed up first on the scene. To answer it this way, I need to go back to Justice Quince's question. I don't view this as a duty to maintain case, and that's why that's a DOT thing. I'm not here on that. This is a duty to warn case, the way I see it. And under the duty to warn, it's only the FHP that could serve that purpose and do that duty. The DOT couldn't do that under the circumstances presented here. And therefore, I don't want to give you the analogy, but I'm going to anyhow, that in the Bailey case, we dealt with overgrown things from adjoining landowners at the state owed. That was a static condition, it was liable. In this particular circumstance, under the compelling facts that are presented here, this is an obstruction. This is something they had knowledge of. This is something that wasn't changing. It wasn't a fluid situation. There weren't...
Well, in distinguishing the duty to the specific person or the specific situation, there are cases where we seem to have approved if the police actually show up and now take over the situation. And for instance here, if they had arrived at the scene and attempted to set up proper warnings or whatever, but were unsuccessful, that is, that they were negligent in the way that they did that, so that they played some role then in the happening of the accident. But isn't the implication, though, from those holdings that there has to be that direct assumption of responsibility before we will extend a duty to them? And could you, with the Chief's help, would you respond to that?
Well, what this court's cases hold, as I understand them, Justice Ann stated, go down to a special duty dichotomy, that when you're dealing with discretionary functions, which is what the way you're putting it to me, once you deal with a discretionary function, there has to be a special relationship. That relationship, according to the case law that I have read, is established when the police take control of the scene. There's those terrible cases where they have the people on the side of the road, somebody comes along and crashes, they didn't secure the area correctly, held liable. But this case, and there are at least the Hoover case, the Hartley case, the Lasky case, not the Lasky case, I'm sorry, the Cook case, all talk about the obligation of the police departments to warn when they are given knowledge of a condition. And sometimes these things, and the distinction is that they fall within the allocation of scarce resources. And when they make discretionary calls on how to send their police out, on a discretionary call, that's one thing. If they don't have enough policemen in the field, that's another thing. I would say to the court, in those circumstances, there can be no liability. But here, the district court found, and the evidence was clear, that there was more than ample police, more than ample troopers available to take this call. And as such, we ascribe to the theory contained in Hartley that once they agreed to send the person, they didn't have to do that. He could have said, you know, we're packed, we'll do it as quickly as we can. That would be one thing. And then I would say that it's just a diversion of scarce resources, and they're entitled to make those judgmental calls.
You're going to use all your rebuttal time.
Okay, I'm sorry. I would respectfully request that we reserve on the rest. Thank you, Your Honors.
May it please the Court, Sherry Weisenborn on behalf of the State of Florida. Also, Mr. Charles Pappy, my partner, who will speak to the issues that Mr. Citrin presented to the Court, and I will speak with regard to the duty issues and Mr. Levy's argument.
Please be aware of your time.
Yes, sir.
With regard to your duty position, assume with me for a moment, if you will, that the call had come in, and it's a canister of anthrax, and it's sitting on the state highway in an exact location where a school bus is going to hit the canister. Now, is that the same duty that we're talking about here? If it's the same, why so? If not, is that a different situation?
I have to say that if we look at the traditional negligence law and we look at duty, which is where we have to go, let's forget we're dealing with the sovereign, although in this instance, because we're dealing with the sovereign, we get into the Category 2 police powers. But what you're asking is, if it had been a normal police force, was there an obligation to go out to that scene at that point in time for the protection of the public at large?
Well, I'm asking whether there's a civil duty arising from that, because those kind of exaggerated circumstances.
Under the current law, and which I believe has been the law from time immemorial, the answer is no, there is no specific duty, because that is a duty that is owed to the public at large and not the specific individual. Now, you get into other emergency situations, and that becomes a deployment, because isn't the police department entitled to decide how it is going to deploy? This court has traditionally held that. That is because, again, we go back to the common law, and if there's no common law duty, then you have to look to statutory duty. Is there a statutory duty? There is no statutory duty to the policeman.
Well, you say this was the law for time immemorial, but the commercial carrier case expressly refutes the position that you're saying and says that that becomes absurd, because if you say a duty to all is a duty to none, then there is no duty of care. And
there's a specified duty in the commercial carrier case. It is not a statutory duty. It is not a duty that is a common law per se. If we just said this is an individual sovereign, what we have in commercial carrier is that it's an undertaking, a voluntary undertaking. Had they never put any signs up or road signs or traffic obstructions up, there would have been no duty. But the state undertook in commercial carrier a duty of placement. And once it took that duty to place, it now became responsible if it negligently entered into that undertaking.
Well, what if we have obstructions on our roadway? Trees fall, and there's a tree that has fallen, and it is there for several days. Is there anybody that's got the obligation, if they're on, to remove the tree that's fallen?
Maintenance is DOT based on statute, and the owner of the property based on statute, and the maintenance is DOT. FHP's duty by statute, and I would note that the statute says we will treat FHP like other police enforcement officers.
So did the 911, when they dispatched, when they got the call and they sent it to the Florida Highway Patrol, did they send it to the wrong agency?
No, there is no doubt
The
that
DOT?
the correct agency, well, to patrol a highway, obviously, the traffic obstruction is part of the patrolling. The department has the right to decide how to deploy itself. Yes, 911 contacted FHP. We cannot deny that FHP's dispatcher did not contact a trooper. But then we have to carry further and go beyond. If we want to go that direction, we have to now go to the probable cause, because remember, in negligence, there's 3 elements. One, anyone that is missing is fatal. And if you go to probable cause, assuming there's the duty, the probable cause is missing because you're assuming that...
You don't mean probable.
Probable cause. Remember, proximate cause. Sorry. You're right. Proximate cause. If you get to that issue, the proximate had assumed that the trooper had been notified. If that trooper on his way to that scene had seen a drunk driver going back and forth between 2 lanes of traffic, crossing over the medians, he would have been off that obligation, possibly, because again, that becomes a deployment issue, and he would have stopped the drunk driver. They never would have gotten to the scene, and the accident still would have occurred. And you get to this issue, these girls took no evasive action whatsoever, yet there were other cars out there that missed the accident altogether, and they ran over the triangles that were out there.
Now you're arguing facts, are you not? That is,
yes, but that goes...
Traditionally, we have left, whether it was actually caused by the... So, I mean, I'm not sure whether... Are you conceding duty now, then?
No, I'm not. I'm saying assuming there was a duty. I am not conceding duty whatsoever. There was no duty. This is a duty owed to the public at large. It was not specific, and if we look at every case that this court has carved out an exception to in sovereign immunity, because it's got to decide what sovereign immunity means, we will find that there's been either a specific statutory duty that said you must do A, B, and C, and there's a particular person who's intending to rely upon that, or we have a voluntary undertaking such as your case.
Let me ask you now we're coming back to Mr. Citron's proposition about perhaps having a restatement with reference to the waiver of sovereign immunity, because don't we end up then with the legislature's broad waiver of sovereign immunity as originally interpreted in commercial carrier, then really being tossed out under this kind of construction of that, yes, there is a duty, okay, but it somehow is this sort of undefinable duty to all, but that really means that nobody is protected under that duty. And so we really end up with no waiver at all in the broadest category of cases and the most obvious obligations to do something out there.
If I'm understanding your question correctly, sir, I think what you're overlooking is that the statute says that the duty or the individual, meaning the state, shall be held responsible like a private individual. There are no duties on a private individual to go out to the highway.
If I contracted for somebody to go out to the highway, and then I told them this thing was dangerous, and if it wasn't removed in the next 20 minutes, that people would be killed out on the highway, and they contracted with me to do that, and they agreed to do it, and then they went to the bar and started drinking and forgot that they were supposed to be, and people were killed out there, those people would be held directly liable for that, would they not? Because clearly, if they had removed it when they said they would do it and all that, it would have been taken care of. Why should a government agency that where everybody concedes is completely fouled up, and they got the call and there's this terribly dangerous thing out there on the highway, and they didn't go out and take care of that, why shouldn't they be held liable, just like the private entity that had been contracted to do that?
Because the private entity didn't own the highway, is not a governmental agency, and it is not something that is part of governing. You remember, we're still talking about traditionally the waiver didn't intend to create a new duty.
Well, I take it that this 9/11 situation is all a fraud. It's all a fraud on the public, that we really have something like that means something.
It's a matter of convenience to try and let the public have one place, and again, let's not get hung up, it's not a 9/11 issue. The issue goes to what was the duty, assuming they got and did what they were supposed to do.
To allow Mr. Pappy to, but Justice Shaw, you had a question?
Yes, I have one question. Would a duty arise if if the dispatcher says, yes, we will do something about this hazard in the road, and there is a highway patrol protocol that says, once you get this type of call, this is what you do? Would that lead to a duty?
You're asking whether or not simply the internal policies and procedures of the department themselves would create the duty?
No, not just the protocol plus the affirmative answer that we're going to do something.
I think under the traditionally, and the Hartley case is why it's distinguishable, had the promise been made to these girls, then there was a special relationship created between the girls and the department. This was simply, fine, we'll take care of it. It is not the promise that happened in Hartley, where Mrs. Hartley detrimentally relied that the police would go out and do something, and they didn't, so she stopped. And her husband.
Is that an affirmative answer? Yes, a duty will arise.
No, I don't believe a duty. It has to be statutorily, it has to be common law, or there has to be some special relationship. None of those entered into the picture in this instance.
Thank you.
Mr. Pappy.
May it please the court, my name's Charlie Pappy. I have done a lot of work in representing the Florida Highway Patrol and DOT from time to time, and there is a big difference between the two. DOT, of course, has a duty to maintain the highways, etc. The Florida Highway Patrol doesn't have that duty to maintain the highways. The Florida Highway Patrol is a police agency. In the situation we have here, if you go back to the case that was cited by the plaintiffs, originally, talking about the boat incident and the sheriff. In that instance, the wife called the sheriff and said, my family hasn't come back. They left their boat there. They went out to sea. Would you go check the boat ramp? And they come back and say, well, we checked the boat ramp. The car isn't there. When, in fact, they never did go out there. And she relied upon that, and therefore no search was started. And therefore the court said, and I think wisely so, you created a special relationship with her. There was no special relationship created here between the girls that died and the Florida Highway Patrol. If you're going to follow their suggestion, then you've got to reverse your line of cases where you have someone negligently allowing a man who's under arrest and is in jail to escape. We've had them where they forgot to lock the door and the man walks out and he murders someone 3 blocks away. We had that case. And you said, wait a minute, there's no special duty to the man that was murdered. But there certainly was a duty to keep that man incarcerated, and we failed to do it. You're getting ready to put... What they want you to do is put a big burden on the state that the state presently doesn't have.
Mr. Pappy, with regard to the warning cases that have been argued by the opposition.
Yes.
Certainly, we know that there are cases, like the Nielsen case, where the law seems to be that if the state in designing and constructing a roadway creates a dangerous condition, there appears to be a duty to warn, maybe not the FHP, but an underlying duty to warn. Would you agree that that's the basic status?
Basically, but it's not quite as simple as it was put, Judge.
Are there cases in your experience in dealing with DOT where we have encountered hazards that are created by others and this warning issue, and if there is a duty, who that duty falls on?
Yes, if the duty falls upon DOT, number one, if they have notice, and they have a notice sufficiently, a length of time in which to correct the situation, et cetera. But if it's a design defect, then you have said that there is no liability on behalf of DOT. Because, as you know, most of the design is done by outside engineering firms,
Well, I
for
thought
which
that-
there
I
is a
thought-
lawsuit
I thought
against
it
them.
said if you create a trap.
That's true. If you create a trap, that's an entirely different situation. Yes, so we're responsible for that. But here we have a situation where they want to make the Florida Highway Patrol responsible for accidents that occur because they did not get there in time enough to prevent it. Now, frankly, you know, approximate cost does have something to do with this, because there was no testimony any time that if we got there, we could have moved the truck. We don't move trucks. We have no way of removing that obstacle. Sure, we can have blue lights and sirens going, but we have troopers run over in the street. Our own cars are hit while we're at the scene of an accident with every kind of light running.
Well, if the facts were that the Florida Highway Patrol had gotten to the scene, and then in the way that they directed traffic, they say they had flares, but they didn't put them up in the right place. Would there be liability in that situation if once they got to the scene, if they handled it negligently?
I don't think so, because I think those are all judgment calls when you get to the scene as to what you need to do first, and what you have to do at the scene, because first you're there to take care of the injured,
So
if
that-
there are injured.
So the reason, I'm trying to separate the different reasons. So in that situation, what you're saying is that there'd be still a planning level decision at the scene about how to redirect traffic?
Well, there might very well be, because the trooper might be all alone and he might have other duties there. The other problem you have here is because this is 4 o'clock in the morning,
Well, but let me,
there's no showing that we could have gotten a trooper there into that length of time.
so that's,
anyway.
again, that goes back to the proximate cause
Yes.
issue. What if in the same situation, instead of it being a third person that had called the Florida Highway, or called 911, it was the owner of that disabled vehicle that had made the call and said, I've got, you know, my daughter is in this vehicle and it's stalled, I can't get AAA, please send someone. And they, again, the same thing, 911 had called the Florida Highway Patrol and someone just neglected to put the call in. Under our law, you're saying that in that situation, is this a special duty created and there would be...
No, I think the special duty is only created under our present law once the patrol arrives at the scene and then has a relationship with that person. Just like we've had people in our custody injured from time to time. You've always held us liable for that and should be. We have this in one of the famous cases that came up here that I argued here 25 years ago, or 30 years ago in this court, was where the city of Fort Lauderdale got a call from a jewelry store that they were being armed robs at the time. They sent one car there. Both of the police officers had their guns removed, and burglars tied them up and left them there. And 8 hours later, they went back to the jewelry store because they had never heard from the police officers that had sent there 8 hours before. In the meantime, that jewelry company lost $5.5 million in jewels, for which it sued the city of Fort Lauderdale. And he said, wait a minute, there's no special duty owed to them any greater than it was to anybody else. And therefore, Mr. Jewelry Store owner, you can't collect, because this is a police duty, and we can't tell them exactly how to function. And I think that's what the situation is here. We don't have a special duty, and they want you to change the law. And of course, that's your privilege to change the law. But if you change the law here, you're making one tremendous economic impact upon the state of Florida. If you're going to make us responsible for everything that happens out there on these highways, we can't police them that well. And I don't see where there's a duty here, and I think that's what we have to stick to, is unless there's a special duty created, we can't hold a police officer responsible for what the end result was. Just like we can't hold him responsible for not arresting the man that an hour later is back in another automobile and runs over someone else, or the man that the lady comes in and says, "My husband wants to kill me," and the police officer says, "Well, you know, what's he done to you?" And then the police officer decides not to do anything, and 2 hours later she's dead. These things do occur. And I think it's too much responsibility to put upon the highway patrol.
The Pariente situation that she just gave with the truck driver calling and saying, "My truck is incapacitated, my daughter's in the back." And, he calls us into the dispatcher. Dispatcher said, "Don't worry about it, I'll send somebody out there." With that assurance, the truck driver does not call DOT, doesn't do some other things that he might have done had the dispatcher told him, you're calling the wrong person, you need to call somebody else, so you need to get a record. With that assurance that something's going to be done, he fails to do anything. Has any duty arrived?
We'd have to show that if he would have done something, that the incident wouldn't have occurred. And that you can't do. There's been no testimonial, no expert testified about any of that.
Well, that would get into the facts.
Well, you know, somehow or other you can't distinguish everything in this case.
Duty at this point.
This case was a miscarriage of justice as far as our present laws are concerned.
Well, my question is, would a duty arrive in that hypothetical?
I don't think the duty would arrive until the police officer arrived on the scene. Because I think that would create the special duty. Now, if he never did anything else about his daughter being in the truck, and hours went by, like it did in the boat incident, when the sheriff told him that the boat had left the ramp, or that the truck had left the ramp hours before, and it was the next day before it was discovered that it had not left the ramp. Then you had a great number of hours went by. That's when you decided that there was a special duty order.
Thank you, Mr. Pappy. Your time is up.
Thank you.
Thank you, Counsel. Rebuttal.
Thank you, Your Honor. If I could make 4 quick points. One, in response to Justice Pariente's question, believe that your question as to the flares and how they did things in negligence is controlled by this Court's decision in Kaesner v. Kolb, which pretty much says that once you get to the scene and you take control, you can be liable like everybody else. I don't think that's really an issue here, notwithstanding what Mr. Pappy says. Second, my good friend Mr. Pappy misreads the Hartley case. Hartley turned not on what he told you, but squarely, and I'd invite the Court to read the case, which I know you will, squarely on the fact that they said they were going to send somebody out and they didn't send anybody. He says it's a special duty case, but the opinion itself belies that contention. It says, well, discussing special duty, it says, well, this is a correct statement of the law. It is not applicable to the facts of this case, where notwithstanding the absence of any pre-existing special duty to Mrs. Floyd, the Sheriff's Office agreed to perform certain activities at her request. Once again, having assumed the undertaking, the Sheriff's Office had an obligation to carry it out with reasonable care. Third, I don't want to get down to proximate cause. I thought we were on appeal. I thought that was settled. There was a jury verdict in this case that determined all that has never been set aside, that held the Highway Patrol 50% at fault. Proximate cause is a jury issue. They found it, and we're beyond that here. Fourth.
Thank you, Mr. Levy. Your time is up.
Thank you, Your Honors.
Thank you, Counsel, for your assistance in this case.